Move.
Brett? Okay.
Second.
Motion by Ford, second by
Bartley.
Bartley.
I got there.
All in favor, say aye.
Aye.
Opposed? Motion carried. Items to be added to the agenda by commission members or staff.
Just our standard staff report, that's all.
Okay, thank you, Mr. Hill. Invitations for citizens to schedule time on the commission agenda for an item not listed. Time limited to 5 minutes per person to address the board. When I look out in the audience, I don't see anyone, so I'm assuming there is no one. And we need a motion to approve the agenda as read. Is there a motion?
Motion to approve.
Motion by Nelson,
Second.
second by McHugh. All in favor, say aye.
Aye.
Opposed? Motion carried. Need to read the opening statement. The Brookings County Planning Commission is a 9-member commission whose function is to recommend approval or disapproval of land use plans, zoning ordinances, subdivision plats, and amendments thereof to the Brookings County Commission. The Commission makes its recommendation based on the adopted comprehensive plan for the physical development of the unincorporated areas of Brookings County. As a matter of policy, all motions are made in the positive. After a motion is moved and seconded, it is open for debate. Those supporting the motion shall, in turn, give their reasons. Those opposing the motion shall then offer their reasons. After everyone has been given a chance to be heard, the Commission shall recommend approval or disapproval based on the testimony and information presented. Simple majority vote of a quorum of members of the Planning and Zoning Board in attendance is required to forward a recommendation. And with that, we move on to the item number 6, consideration of plats. 2019 Plat 003, plat of WWTF Lagoon Addition in the north one half, section 24, township 110 north, range 51 west of the 5th principal meridian, Brookings County, South Dakota. Is there a motion to approve this plat?
So moved.
Motion by McHugh,
Second.
second by Davis. Richard?
Yes. Plat 2019, Plat 003. The city of Volga is replatting property where their wastewater facility and lagoons are located. The facilities are now located on 3 separate parcels known as plat of lots 1, 2, and 3 of Volga Lagoon Addition in the north half of section 24, township 110 north, range 51 west of the 5th prime meridian, Brookings County, South Dakota, and in the plat of Brookings County Soybean Processors Track B as platted as part of South Dakota Soybean Processors Track A, Track 1A, and Track 1B, the northwest 1/4 of section 24, township 110 north, range 51 west of the 5th prime meridian, Brookings County, South Dakota, and plat of lots A and B in the north half of section 24, township 110 north, range 51 west of sewage treatment facilities. These existing plats will be vacated and the parcels will be combined into one large parcel with a new legal description as stated above. On there, copy of the plat. Dark outside line is the new parcel that is being made. Lines right in here are the existing parcels on there. Overhead view with a beacon map. The dark blue lines are the existing parcels here. The red line is what the new parcel will be consist of. Just a beacon map of this parcel here. Inner parcel right here. It's just a replat of the property into one legal description for their wastewater lagoon upgrade. So it has one legal description for their purposes. And that's all that I have.
So more or less, it just cleans it up and makes everything simpler.
Correct.
Yep. Questions or comments from the board? Seeing none, we'll open it up to the public. Questions or comments from the public? Seeing none, we'll close the public and back to the board again. Richard, call the roll.
Bartley.
Aye.
McHugh.
Aye.
Nelson.
Aye.
Kleinjohn.
Aye.
Ford.
Aye.
Spence.
Aye.
Davis.
Aye.
Rochelle.
Aye.
Motion passes.
Moving on. Brookings County Board of Adjustment. Board of Adjustment is the Board of Adjustment is a 9-member board which has the power to hear requests for variances, conditional uses, appeals, and special exceptions. The concurring vote of 2/3 of the attending members is necessary for approval of any action of the board. A 9-member board requires 6 votes, and a 6-member board requires 6 votes. In accordance with Robert's Rules of Order, we require a motion to approve a request before the request can be debated. As a matter of policy, all motions are made in the positive. The board, under specific powers granted by the state, shall authorize variances from the zoning requirements where special conditions existing on the land will result in unnecessary hardship for the applicant. Financial disadvantage to the property owner shall not constitute proof of unnecessary hardship. Agenda item number 7, 2019 Conditional Use 002. Lane Sadoff has made an application, 2019 Conditional Use 002, to the Brookings County Board of Adjustment for a conditional use, Article 11, Section 1101, A, Agricultural District, Conditional Use Permit number 20, Home Extended Business. Property is described as the southeast 1/4 of the southeast 1/4 of the southwest 1/4, Section 18, Township 112 North, Range 51 West, which is in Preston Township. Located at 46044 199th Street, Bruce, South Dakota, 57220. Is there a motion to approve?
So moved.
Motion by Kleinjohn,
Second.
second by Nelson. Richard?
Yes, conditional use 2019 CU 002, having been applied by Lane Sadoff, has applied for a conditional use permit number 20 for a home extended business. The applicant has a farming operation and would like to add a home extended business to sell used cars, pickups, trucks, and trailers. The location of his farm is 1/2 mile east of 460th Avenue on 199th Street, which is a Brookings County Blacktop Road number 4. His business plan is included in this report, and he will use an existing 40 by 80 building as a sales center for the dealership. He plans on keeping an inventory of 5 to 6 vehicles /and/or trailers on site. The hours of operation will be on call and by appointment. The applicant will need to meet the requirements of the dealer's license from the South Dakota Department of Revenue. The comprehensive land use plan for Brookings County on page 72. Brookings County encourages businesses to operate by the owner or tenant of the property. On page 73, Brookings County may permit businesses operated by the tenant of the property which may be similar of a character to other uses allowed in the agricultural district, included but not limited to gravel hauling, asphalt, contracting, commercial hauling, general contracting, and construction. Public notices were published in the Brookings Register on January 22nd and 29th, 2019, in the Volga Tribune on January 24th and 31st, 2019. Letters were sent to the adjoining landowners, Preston Township Chairman and Clerk, and we received no comments from the public, the adjoining landowners, or the township officials. Here's his conditional use application. His business plan, stating his business hours be by appointment. Traffic is minimal, maybe 2 to 3 contacts per day, and he's planning on keeping 5 to 6 vehicles and/or trailers on site. Beacon map of the residence. This is the building he plans to use as a sales center for his business. House here, rest of the property right there. This is just looking from his driveway, looking to the west on 199th Street. Clear vision going to the west. This is looking to the east on 199th Street. Clear vision going that way. This is just looking north into the farmyard, into his building that he will use as his sales center for his dealership. And that's all that I have.
Okay, thank you, Richard. Mr. Sadoff, you want to come forward and tell us anything that Richard left out? Just to let you know, there's only 8 voting people up here, 8 members instead of 9. So there's 1 vote that you may have that could be a disadvantage to you. So we can proceed if you would like. Otherwise, you can, we can table this till the next meeting till all the board members.
No, we can proceed.
Okay,
So thank you. Yeah, am requesting, I guess it would be conditional use. Is that the correct term? I have had an existing dealership or dealer's license to do this for coming up on about 4 years now. I own a small dealership here in town that I have another person who's kind of the face of it. And I am going to, that one's kind of going to be taken over by that gentleman. And that's going to kind of remain the same. And then I'm going to move, or I would like to move the existing dealership that I have out to my farm. And as the business plan stated there. So I've been doing this a little while, and this is more of a, I like to kind of concentrate more on the, I guess you could call them hot rods and that type of vehicle. And I do some online stuff. So I anticipate that there'll probably be some cars inside of that building that may not sit outside at all for that reason, because they're a little higher end cars. And also there'll be some, I don't anticipate more than, that 5 or 6 that would sit outside for sale also. And the traffic, is going to be very, very minimal, I would anticipate. And the hours and things like that you're open and all that is controlled by the licensing people from the state to have the dealership. And I've been in contact with them, and everything's okay to continue on being a dealer and keep my license, as long as I can get this conditional use approved and move that out there to my farm. So that's kind of the essence of it. I'm not new to it. It's just a little different twist for me, and kind of rolling out of one that's already in town here and moving out to the farm. So you guys got any questions for me?
Are you gonna have any signage?
There'll be, that is part of the dealership requirements, is to have some signage also, so I'll have to conform. I don't recall to whatever the regs are, that you guys have for signage. I think is it 4x8, or I don't recall what they are.
Right now it's 16 square feet.
16 square feet.
So, but if that changes, then you would be able to go up to that size of.
Yeah, so it'll probably be something attached to my building, just to identify me somehow. No blinking lights on the giant arrows, or 20-foot tall balloons waving in the, none of that kind of stuff. Pretty low key. Like I said, some of the stuff, most of the stuff I do will be online. So I like doing that, and I have the building in the area to do it out there. So I have had some requests from a few people for some semi trucks. So, you know, there might be, I don't anticipate there would be more than one of a semi tractor possibly sitting there. It just depends on the request that I get. So.
Mr.
Comments?
Sanoff, go ahead. I have just a couple of questions.
Yep.
Obviously, you're going to transfer your current license to this location based on the state's approval of the new location.
Yeah, I have a tentative approval with them now.
Okay.
I just need to provide them this letter in the positive of my conditional use for
So
tonight.
they-
And I'll actually be keeping my same dealer number and everything. It won't be a new,
So the person taking over your business in town will get their own license.
they're
It's
gonna
not
have
an
they're
extension
gonna
of
have
your
a
license.
different dealer number,
Okay.
but they're going to maintain the current name.
Okay.
And I will just change my name for my dealership.
The second question I have is that the county may permit businesses operated by the owner or tenant of a property, which may be of a similar character to other uses, blah, blah, blah. But then my question is it, are we, Bob or Richard, are we issuing this tenant only or owner only? Could he possibly lease out the business at a later date on this particular property as a tenant because that's allowed in the ordinance?
I don't, correct me if I'm wrong, Mr. Hill, but no, that's not possible.
Okay,
It
so this
goes
is,
with the, I mean, if he sells the property.
it
then
goes
the
away.
conditional use can go with it.
The use can go with it on the conditional use, but if he rents out the
Yeah.
property, the building to someone and says, hey, I'm gonna rent out the building for the
They'd have to
dealership.
come in for their own conditional use permit, because then it's not an extended home. If they're not living in the home on the property, then it's not an extended home business. It becomes a commercial.
So tenant is defined as living in the house, not renting the building as a tenant.
Correct.
I'm new, I'm asking a few questions, not in opposition, just
That is-
clarifying things.
That is currently not the plan.
Okay.
To do what you're,
No, and I'm
hypothetically.
not suggesting that it is,
Yeah.
it's just
I just
sometimes
wanna
there's
be clear.
unintended consequences to things when you
yeah,
do it. So
you gotta do that.
wanted to make sure there weren't any unintended consequences of law.
Mr. Chair, tenant in this case would be if he rented his farm or building site where he was at and he was applying for it, then he would be the tenant of the land. And he would be applying for the conditional use to do that there.
Okay.
But being he's the owner, it's a home extended
It's one or the
business.
other,
Right.
it's either the owner or a tenant. Gotcha.
And if you dump,
Does the state require or the county require anything as far as its disposal of waste oil and such?
The county
Okay.
does not, and you would have to look under the state statutes for the Department of Revenue, and I don't recall seeing those in there. But he is not
I'll
having a
guar-
shop there.
I'll guarantee you, if he dumps oil on the ground, I know the EPA's number.
I can answer that for you too. That's part of the application process that I went through years ago with them. They want to know where you're doing things at. Are you working on vehicles there? And if you are, as part of your dealership, what are you doing with your waste materials and tires and that kind of thing? And I'm not planning on working on any of these vehicles. Most of these vehicles are already done as far as the restoration process. So I've answered the dealership requirements from the state, so I would answer it the same way to you guys.
No repairs from your standpoint then? No
No,
repairs?
no, I have people in town here that do that kind of stuff.
Okay.
So I do repairs in the other shed for my farm, but not for this.
Further questions from the board? Now we'll open it up to the public, and there's no one in the audience, so we'll close the public portion. Back to the board again. Any more questions, comments? Richard will go through the findings.
Brookings County Zoning Conditional Use Permit 2019 CU002, an application for a conditional use permit having been filed with the Brookings County Zoning Commission, acting as a Brookings County Board of Adjustment, a copy of the application being attached here too. Such application being made by Lane Sawdoff regarding the following real property: southeast 1/4 of the southeast 1/4 of the southwest 1/4 of Section 18, Township 112 North, Range 51 West, Preston Township. After due notice, a public hearing have been held on the application on this fifth day of February 2019. Number one, the Brookings County Board of Adjustment hereby finding that it is empowered to grant such a conditional use permit under the following sections of the Brookings County zoning ordinance. Article 11, Section 11.01A, Agricultural District, Conditional Use Permit Number 20, Home Extended Business. Further finds that granting of the conditional use will not adversely affect the public interest. Number two, the Brookings County Board of Adjustment further finds and certifies that the following specific rules governing the conditional use request have been complied with. Number three, the Brookings County Board of Adjustment further finds that satisfactory provisions and arrangements have been made concerning the following where applicable. A, entrance and exit to property, proposed structure therein, with particular reference to automotive and pedestrian safety and convenience, traffic flow and control, and access in case of fire or catastrophe. Will use existing driveway. B, off-street parking and loading areas, whereas required with particular attention to the items in A above and the economic noise, glare, or other effects of the special exception on adjoining properties and properties generally in the district. No on-street parking allowed. C, utilities and refuge and service areas with reference to locations, availability, and compatibility. None stated. D, screening and buffering with reference to type, dimensions, and character. None stated. F, signs, if any, proposed exterior lighting with reference to glare, traffic safety, economic effect, compatibility, and harmony with properties in the district. 16 square foot sign allowed. F, required yards and other open spaces. None stated. G, general compatibility with adjacent properties and other properties in the district. Comprehensive plan met for the agricultural district. Number four, the Brookings County Board of Adjustment further finds and determines any conditions as conditional use permit upon the following additional special conditions or safeguards. South Dakota Department of Revenue motor vehicle dealer's license required. The Brookings County Board of Adjustment, by at least 2/3 vote of its full membership, hereby grants the above petitioner a conditional use permit for the above described real property for the use as follows. Conditional use permit number 20, home extended business for selling used cars, pickups, trucks, and trailers. This conditional use permit is specifically conditioned upon initial and continued compliance with all the requirements and conditions in 3 and 4 above, upon compliance with all applicable provisions of the Brookings County zoning ordinance. If approved, the Brookings County zoning director is authorized to issue any required building permits for construction consistent with the requirements of this conditional use permit. If this conditional use permit is not used within 3 years of the date granted, it shall be invalid. Dated this 5th day of February, 2019.
Look okay to the board? Okay, Richard, call the roll.
McHugh.
Yes.
Nelson.
Aye.
Kleinjohn.
Aye.
Ford.
Aye.
Spence.
Yes.
Davis.
Yes.
Bartley.
Aye.
Rochelle.
Aye.
Motion passes.
Okay, thank you, gentlemen. Come on out when I get my sign up. I might have a hot rod for you.
What's that?
I think you probably can. There's a lot of poor man hot rods.
I own one.
Do you allow test drives?
I don't know about that. I know where you
Cash in
live.
hand.
Thank you.
Moving on to agenda item number 8. Todd Kays with First District would like to talk about board training, and we'll just give you about five minutes. But you like to get long-winded, so
Well,
we'll
I
add
know
5
I'm
minutes
the
if
only
you're
thing
really
that's
good.
keeping you from the State of the Union address, so we'll try to keep things going on. Do you have the, Richard,
Yes,
do you have
1
the
second.
PowerPoint up? Well, this first of all, an introduction, because I know there's some faces here that don't know me. I'm Luke Muller 10 years ago. My name's Todd Kays. I'm the director of the First Planning District in Watertown, and I've been with the district for about 26 years, but the first 16 years was I basically did Luke's job, who you get to see on a monthly basis. And you guys got the short stick because this is Luke's presentation, and I'm just taking it over for him because he's in Jamaica right now, enjoying himself. And so the other day, Richard had contacted the office and said, and Bob, you had a light agenda tonight, and every once in a while it's kind of nice just to get a little board training. And so don't get bored as we're training here, but we're just going to keep moving forward with that. So Luke and I talked about it, and we said, well, what are we seeing across the district? And we work in 11 counties and 76 communities, and Luke's the zoning administrator in Hamlin County. We have another staff employee that's the zoning officer in Hamlin County. So we got Cottington and Hamlin where we do the building permits and everything. And then I help Grant County out with Board of Adjustment actions and provide staff support on a monthly basis when they're going through their meetings. And so what we thought we would do is just spend a little time talking about, do I get this to, do you have to advance it, Richard, or do I advance it? What we thought we would do is just talk a little bit about agendas, conflicts of interest and ex parte contacts, how do you run a meeting, and talk a little bit about findings of fact. And we're not going to get real deep in the weeds on any of this, but just kind of talk about some best practices that you can utilize on your monthly meetings. And so, first of all, let's just talk about agendas. You guys have a really good agenda, and basically, much of the things that the way your agenda is laid out is basically what we replicate and use in other counties and other municipalities. There's only two agenda items that you don't have on your agenda that sometimes we think maybe you might want to consider. And the one's down there toward the bottom is an executive session if necessary. And the only reason we say that you should have an executive session in there is because we've had attorneys tell us that sometimes boards get in a position where they might need to take a timeout. I always say it's like Barney Fife having a bullet in your pocket just in case you need it. And so sometimes, but if you don't list executive session on your agenda and you don't have the ability, as our Robert's Rules man, Mr. Bartley here, will tell you, we don't have the ability to go into executive session on a whim. So I would recommend having an executive session as an agenda item. You'll probably never use it, but just in the time that you might need it, it's there for you. Yeah, Daryl.
Yeah, Todd, if an executive session is necessary, does that somehow preclude public notice on that?
If it's agendized and we post our agenda 24 hours prior to the meeting, okay, we've met the public notice requirements that you may go into executive session. That's your open meetings laws.
Yeah, and you can remove it from the agenda at the end of the meeting so that people understand that
right.
It's only there as a placeholder.
Yep.
If we need it.
Yeah, it's just basically, but it's nice to have in there. And again, you're not breaking any rules by not having it, but it's just a placeholder. The other thing, and what I'm probably going to spend a little bit of time on, is halfway down the list. It's called disclosures of conflicts of interest, relationships to the applicant, or ex parte communications. And next slide, please. And so why do we really need to talk about conflicts of interest, ex parte, bias? Well, in the last several times I've been deposed over the course of the last year, and Luke will be getting deposed. We'll both be getting deposed probably next month on a couple lawsuits that are going on with wind energy projects in Grant County. Those individuals that are coming after county boards of adjustments, it's not anymore, it's not just that your rule's bad or you're not following your process or you guys aren't just really listening to us in your decision making. They're making attacks. They're attacking the decision makers. They're accusing individuals like you that sit in your position of having bias. And they're trying to use bias as a way to discredit or disqualify the decision that you may have done in the issuance of a variance or a conditional use permit. So we're not going to spend a lot of time tonight talking about conflicts, but we will spend some time talking about ex parte contacts. So in this situation, how does that work in the flow of the meeting? Basically, at some section of the meeting, and I usually like to do it before we get into the actual public hearing processes, the chairperson would just basically ask, is there anybody on the board that needs to disclose any conflicts or particular ex parte contacts that they've had on a particular agenda item, right? And so, and what do we mean by that? Well, if you've had a potential conflict, or you've had this ex parte contact, it's about perception. Is somebody in general going to perceive that this conflict or this action that's happened is going to bias you in your decision process? And so, like, if we're talking about conflicts, what kind of conflicts are out there? Well, there's a Supreme Court case out of Winter. It's called the Hanning case, where the Supreme Court came up with 4 specific tests to see if you have conflict. And the reason they came up with those 4 specific tests is there was nothing in state enabling legislation or any other case law that talked about conflicts of interest. So they came up with a direct pecuniary interest, if I'm getting cash, or I've got an indirect where maybe I'm not getting it, but maybe a family member is getting some money, or there's several other areas where you might have a potential conflict. Decision was made, and it happened to be going on the same time that legislative session was going on, and a few attorneys saw that decision, and within 7 days of that decision, the state passed a legislation that says bias is only caused right now by a direct pecuniary interest in a project. Now, that's currently being litigated in Dual County and soon to be in Grant County here in 2 cases as well in the next several months. So bottom line, we're not going to, that conflict, and what is a real conflict under state law? We know what state law says. It's direct pecuniary, that you're benefiting directly from a cash perspective. That's what we're going to say it is, but always, you think about it, what's it look like from the outside? And that's what you have to think about on those conflicts. Ex parte conversations is something a little bit different. This is where you've had a conversation or been provided information that basically nobody else has access to or is going to be heard before the meeting or the public hearing happens. Next slide, please. And so we're going to spend a little bit more time about that. And this slide, next slide, you can hit another button. It goes twice here. Yeah. So when do you vote? We're going to say, before we get to answering this question, basically, if you're not sure, you need to ask your attorney whether or not you should be participating either on a conflict or ex parte. But before we get there, I'm hoping that maybe through the next several slides you can see that you can be able to make up your mind so that you don't necessarily have to ask your attorney. If you're still conflicted after we go through some examples here, then you still should probably talk to your state's attorney saying, here's the story, should I be playing the game? Next slide, please. Actually, you can go to the next one after that. That's just Luke's entry. So what is an ex parte communication? This here breaks it out in a lot of legalese of what ex parte means. It's outside the realm of the process. It's kind of like there's different levels of ex parte communications. The most recent court cases in Grant County talks about invited versus uninvited. But basically, it's when, if you think about a judge has been contacted prior to the court case, the court hearing, and evidence is being provided to him that could predispose his decision, right? I always liken it to the fact that I'm driving down the road, I get pinched for speeding, that's on a Friday, court's going to be on Tuesday, Saturday night, I'm going out to eat, and I see the judge and the guy that pinched me for speeding. I'm going to be thinking the perception doesn't look good, and there's a possibility that there's an ex parte communication, and maybe it's just that they're brothers or something like that. So you have to think, another one can be is like if on an invited versus uninvited ex parte contacts, the court in Grant County on a recent case basically has said that if the ex parte communication is invited, which means you are inviting the communication, that's bad. If it's uninvited, you've got some cover, and we'll talk a little bit more about that. Next slide, please. So, how could I ever leave my house? That's a Luke quote when it comes to if you're a planning and zoning board member. Well, I coincidentally serve on the City of Watertown's Planning Commission and Board of Adjustment as well. So I sit and I wear the same robes that you guys wear and hear similar situations. And I can just tell you my approach to ex parte contacts and it's not perfect, but being what I do for a living, people know that I have a lot of inside information lots of times of what's going on in the community. But if a person calls me and says, Todd, there's a Board of Adjustment action coming up here this week, and I want to sit down and talk to you about it. Generally, I will, if I know the person, I'll probably swear at them. But if it's somebody I don't know, I usually will say something to the effect that, we can talk about the weather, we can talk about sports, we can talk about your wife, we can talk about your girlfriend, whatever, but I'm not going to spend time talking to you about this issue. Now, that's a little bit more difficult when you have an elected official that's sitting on the Board of Adjustment, but if you do that, that's basically the best thing you can do, because you're taking away any potential legal attack that might come later. And so, but let's just say the conversation goes on. What I normally then say is that, staff will investigate your questions or your concerns. If you have specific questions, staff will look at it. Staff will make sure that that question gets asked during the public hearing. Staff will investigate your questions and your concerns. Then I also say, if you don't want to put it in staff's lap, show up at the public hearing. Why? I don't, he's my neighbor, and I don't really want to, But if you've got a concern, we're going to hear it at some point in time down the road if we approve this, and there's already consternation between the two of you. Normally, I keep track of anybody that does call me, sends me a note. Anything that I receive in a written form, it goes right to the staff that very same day. And so it's available for the public record when we get ready to go. When we get to the actual time of the public hearing, and if I had any conversations, I will stand up and say that I've had conversations with this person, this person, this person on this day. I basically nipped things in the bud, and we didn't get into the meat of any discussions. So basically, we want to make sure that you lay all that information out for the public so that they know. Again, sometimes it's a little bit more difficult for elected officials to be somewhat dismissive, but at the same point in time, I come back and tell the people that are trying to talk to me about this, whether they be the applicant, let's talk about the non-applicant, I tell them, I said, this conversation could negatively impact what you want me to do. I might agree with you that this thing shouldn't be permitted, but this conversation keeps going on, and the applicant's not party to this conversation, and we deny the applicant's request, and this comes out at some later date, I would be prejudiced, and it could put the county or the city in a difficult position when trying to on an appeal. Okay, so next slide, please. What about site visits? That's always a good one, and there's a little bit of case law regarding what to do on site visits. Now, if I'm driving to and from work, and it just so happens to be that there's a conditional use permit on a lot, and I see it and I'm driving, not a big deal. I decide to stop. I take a look, maybe even take some pictures. Still probably not such a bad idea. I pull into the driveway, I get out of my car, I start walking around the yard trying to get a feel of what this is going to look like. Okay. I walk up to the house and ring the doorbell. You see the progression that I'm making. Somebody answers the door. I walk in the house. I'm inviting all of this. And so, you have to think about perception. Some of those things are probably fine, are not going to be a big deal. But when you start doing a lot of independent investigation, you're already trying to get things in your mind. That's why you have staff. That's why staff can go out. Richard does a good job. He took pictures. He presented an overview of what the request is, so that you can come in and hear it fresh. Now, sometimes, and if something's really a big issue, you've probably heard about it already because people either tried to call, there's been a newspaper article, or what have you. What about if you as a Board of Adjustment decide that you want to go out and visit a site as a group? I don't normally encourage that either prior to a meeting, but sometimes we've done it. I went on a wind tour over in Minnesota one day with the Grant County Planning and Zoning Board and the County Commission, and it was put together by the Development Corporation. So what did we do? We put a notice in the newspaper saying that we were all going to be there. And it didn't have to be a Board of Adjustment action, but it was a policy thing. And we also stated that members of the public gave them directions, let them know that they could be there as well, and that no decisions were going to be made that day. And so we wanted to see what a wind tower looked like and what it sounded like in the country. There was a 10,000 head dairy over at Hamlin County a year ago that got permitted, and there the dairy had another one over in Minnesota, and they wanted to let the Board of Adjustment come over and see how bad it did or did not smell. And we basically nipped that in the bud because of we knew the potential litigiousness of that decision. We talked the County Commission and the Board of Adjustment not to go there because we just didn't want to have any perception that we wanted a clean vote, regardless of what the outcome was going to be. So, again, it's something that you can do, but just make sure it's appearance. You know, if you think it's going to look bad, and just a couple guys talking about it, it's going to look a lot worse from other people that don't know what's going on. And so that's what I always try to encourage, is making sure, you know, that the appearance of things. Next slide, please. So what happens when you're getting ready to do this? So if you get to that point where the chair calls for a disclosure if you have anything. And now here's an example where a person says, I don't think it's really, I don't really have a conflict. I mean, I've got my cousin, he's a third cousin, twice removed, and we only see each other on family reunions, and we don't really care for that side of the family anyhow. And he's got this application, but it's not going to be biased. I don't think I'm biased. Okay, that's an example. Next one, please. What about an example for, based on this one here is nothing. John Smith is the applicant. In this one here, I have had some ex parte contacts, but I'm going to summarize what happened and what those things are, and it hasn't prejudiced me. And I can give a fair and impartial hearing. That's a good way of just explaining it. Next, Richard. What about those where you might feel I do have a conflict? Maybe it's not my third cousin, but it's my dad or my brother, my sister, my mom. They've got some money in this deal. And again, while I might not directly benefit from it, they will directly benefit from it. And just because our relationship, it's probably best if I just step down from this decision making. Same thing could very well be as this next one. I attended a private party at John Smith's residence of the applicant. 3 days after he made the application, we sat down, had a couple beers, and talked about what he wanted to do. And I think that the information that I received in that conversation has prejudiced me. And so that's why I think I need to be stepping away from the decision making. Next, please. So what happens, though, if you're during your meeting and Mike gets up and he comes up and he says this thing happened, but I don't think I'm biased. I don't, and Daryl says, oh boy, I'm not sure. Mike's a good guy, but I'm not sure. Daryl can call a point of order where he says, Mr. Chair, Madam Chair, we've heard what Mike had to say. Just for the good of the decision-making process, I think he does have some bias in this, and to give a fair hearing to the applicant, I think Mike should recuse himself. Well, what happens next is then that goes into the chair. The chair will sit there, the chair gets to ponder what Daryl said. And then the chair can either agree with Daryl or not. If he agrees with Daryl, Mike needs to recuse himself. If he disagrees with Mike, we can proceed, or Daryl could turn around and say, Madam Chair, Mr. Chair, I disagree with what you is. I'm going to make a motion to remove Mike from this action item. And if Daryl gets a second and there's a 2/3 vote of the members of the board, Mike has to step down. So that's how that process works. If somebody says they disclose something and they don't think they are biased, the rest of the board, chair and or the rest of the board could remove that person in the decision-making process. And it's just something good to know in the back, in your back pocket. Hopefully you never get there, because hopefully, you don't want somebody on an ex parte communication nips it in the bud before we get to the point where I have to get into a long, diatribe of why I may or may not be predisposed.
Another thing, Todd, sometimes it helps in those situations with the elected officials anyway. If you think somebody on your board has a conflict and you don't know if they're going to disclose it, and you don't want to be that person to disclose that conflict, have a conversation with them ahead of the meeting and
Right.
just say, look,
Yeah, we don't.
on item B in the agenda, you know, do you have a conflict? Do you think you do because of, state it, and if they say, well, yeah, I kind of do, well, will you recuse yourself?
Yeah.
If they say no, you may even tell them at that point, I think you should. And conversation to decide at that point whether you're going to bring it up as a point of order.
And that's where, again, it gets back to this perception. If
Yeah.
I kind of think I might or I might not, what does the outsider looking in think? They're probably going to be a lot easier to say you are or you are not.
Generally speaking, if somebody thinks you have one, you probably do.
Yeah.
In most
Questions
cases.
on conflict and ex parte contacts and how best to handle those if you are so dealt that hand.
So something is, Todd, something as simple as I share a fence line with one that had an applicant here at one time, and I like to have a good relationship with him because with that fence line, our bull gets into his pasture. He needs to not shoot my bull.
Right.
And anyway, I want to have a good relationship with him. But on the other hand, I think I can be fair, and I think he can be fair.
Yeah, and I think, I mean, that's a relationship. Does that relationship cause bias? Let's take it the next step. Maybe the guy that's at the other side of the fence is your father-in-law, and father-in-law is asking to put up a 5,000 head CAFO, of which maybe you are backgrounding some of those cattle for that CAFO. Now we've kind of taken it to another whole new level, right? So, good question.
It could also be used against you if the neighbor's a friend or not.
Yeah, that's exactly true.
If
So,
he's not a friend, you may be biased not to.
you know, Supreme Court Justice Gilbertson, though, he dissented in the Hainig case when they were talking about trying to come up with ways to be, you know, that shows bias. And he said, you know, we're in a state of 800,000 people. We're all one or two degrees of separation of something. We probably all have some level of bias just because of the nature of where we are and where we live.
That's why I think, Todd, the pecuniary interest is there a monetary value to your vote?
And I
to
think
the
that's why
applicant.
the legislature, it was at that time Senator Schoenbeck was the one that introduced that legislation.
And even
So,
that gets a little gray at times, but if you think there is, there probably is. Use that as a rule.
yeah, the whole Hainig case was an interesting case. That was based upon a woman who sat on the Board of Adjustment in winter. She was a waitress in a bar, and another guy across the street wanted to open a new bar. The bar owner told the woman that sat on the Board of Adjustment, you should really vote no on that because we don't need any competition across the street. And the Supreme Court, and that's what ended up happening and didn't get enough votes, and so the Supreme Court basically said that that was an indirect pecuniary interest back to her, so she was biased. And so that's how that whole court case came about. It's kind of interesting. Next slide. We're just gonna jump a little bit just in on public hearings, and you guys ran one here tonight. It was very well run. You know, there was no mob in the room with torches and pitchforks, so it was a little bit easier to get through it. But we're just gonna talk just a little bit on how you might slide, please. Want to consider improving what you do. And I'm not saying that you do anything wrong, but these are just some ideas on how to run a public hearing. And as I go through this, you're going to end up saying, yeah, that's what we do already. And you're going to hear it because you do a very good job. But next slide, please. And you can hit a couple because there's two more bullets. Always at the beginning of that public hearing, you call it detention, and it's what you did. Bob did a good job. We're having a public hearing. And a couple other things, sometimes it's just nice to know. Here, you've got a great building because it's obvious, you know, we've got video and we've got, you know, we're recording it, but the public should know that it's being videotaped or it's being recorded, or we're only using written notes to transcribe what happened here at the meeting. We want to talk about what the subject was, and Bob did. He explained it. Sometimes you guys have nameplates. I've been places where there are no nameplates and there's people from the outside, they don't know who the hell they're talking to. Sometimes, so it's nice to introduce the board so people understand who they are, where they are, and where they're from. Whether or not they're an elected official or not, we understand you guys, but that's a good thing to do. It's really important just to explain to them on the very initial part, the very first time when you're out of the gate, that this is a citizen participation process. You know, we are going to want you to come in, we want you to comment, we want you to be a part of the decision-making. You know, there's going to be a staff report, the applicant is going to give a presentation, there'll be opportunity for public comment, and then we're going to close the public hearing, and then, so you kind of just lay the rules out ahead of time before we even get into what's going on, at least the first one out of the gate. Next, please. 2 more bullets, hit it twice, yeah. So we talked about that, you know, that once we close that public hearing and we bring it back in, when the applicant might be brought back up, ask questions, the board might ask questions of the audience, but there's no more direct conversation from the public regarding the public hearing process. And we also tell them that everybody gets a chance to talk, you know. Now, rules for comment. I was most recently in Grant County 6 weeks ago. We had 104 people in a room that probably could fit 75 comfortably, and there was no other place to have or move the hearing, but that's where we were at. And there were so many people there that if we would have had an unorganized process for gathering public input, we would have been there. Well, we were there from 4 o'clock to 11 o'clock, and we were there for 7 hours. Anyway, it would have went another 2 or 3 hours. So what we end up recommending doing is that if you have a large group, everybody should sign in anyway, who's here. In your sign-in sheets, very much if you've ever been to the legislature and you have to testify out there, you state your name, your address, and you sometimes say what is it you are here for, and are you a proponent or opponent, and do you want to speak? I would recommend doing that. And then you have that up. And then what you end up doing is then rather than letting people come up as a cattle call, you have a gatekeeper. And that could be staff, it could be the chair. We gather everybody's sign-in sheets. We ask, anybody else still want to testify? Okay. We count how many people have signed up to testify. We got 45 people to talk. Now you as the board have to determine how long do we want this public hearing to run. And the Supreme Court has stated that we as a board can determine what the minimum or maximum amount of time anybody can be provided. Normally we see 3 to 5 minutes is what we're seeing across the board. So we figured out we got 45 people here, and we think, we want the board, what do you guys want to do, 3 minutes? Want to do 5 minutes? Okay. Now we know what the maximum headroom is going to be on that. And then they know, too, that they can turn around and have their thoughts in a place that they can get everything expressed in that 3 to 5 minute time frame. We ask them, you know, if you're going to be an attorney or if you're representing a group of people, who are you representing? We want to know that. We want to know when they come up, you ask them to speak their name, their address, and then that they directly talk to the board. Next slide, please.
You can also usually allow an attorney a little bit more time.
Yes, and that's normally what we recommend.
Generally cover the entire issue.
Yeah, we recommend that you give them a little bit more time. But there's some time limit requirements. You know, we make sure everybody respects their time. If people, we don't allow people to trade minutes. I'm yielding my 2 minutes to, no. Everybody gets the same amount of time to come on a pro or con side. If we get through the whole process and you talk about that they didn't sign up, but all of a sudden somebody's sitting in the audience, they thought, oh, I wanted to say something. I always, at the end of the meeting, recommend that at the end of the proponents, is there any other proponents that did sign up that all of a sudden had a wonderful thought in their head and they want to express it and share that? We're going to give you 1 minute. And then you give them, and then you do the same thing on the opponent side. We also want to make sure that there's ground rules, you know, no personal attacks. You know, you have to stick to the merits of the case. You know, if the hearing is on the wind farm, we don't want you there reading from Leviticus for 3 minutes on whatever, the evils of Ham. You know, so we want to make sure that everything is to the point and there's purpose for your comments and purpose for what we're trying to get accomplished. And again, in all conversation when you're presenting or hearing proponent or opponent testimony, it needs to come to the board. I don't get to ask questions of Tom. I don't get to ask questions from anybody in the audience. If I have a question I want to know, I'll ask Mike if he's the chair, or I'll ask Bob if they're the chair. And you don't have to answer that question right now. We'll just make sure we write it down because we're going to come back to it. Next slide, please.
Can
Yes,
I ask something? If So we got those 45 people, if half of them, 20-some want to be our proponents, and they want to state their same thing, and we have to suffer through 20 of the same points?
My recommendation is that you state that if you're going to repeat nearly identical testimony, you say, I agree with what they said, ditto to what Terrell said. You know, if you start saying that they're repeating what other people have said, that's when the chair usually should enter in and say, do you have anything new to offer? Why we understand that you agree with every Tom, Dick, and Harry that just came before you, do you have something new? Or
Yeah,
could you
basically state that you agree with comments
Yep,
made by
exactly.
the previous presenter, and identify the presenter if they
Yep.
can. And at the same time, it's real important for the chair to tell the audience, we need all pertinent information. If you have something new, we encourage you to come up and give us that information, but don't repeat what we've already heard, because
we-
that doesn't help us with our
And the
decision.
chair's got to be careful not to quash any sort of things that are going on there. And so that's why you give them 2 or 3 shots. But if it's the same thing what Shirley just got done saying, and Shirley just said that, is there anything different that Shirley didn't say that you want to say? You know, I mean, you can be polite, you know, but after about 2.5 minutes of a 5-minute speech and they haven't really said anything new, I think at that point in time the chair could say, I'm going to give you 30 seconds to wrap it up.
What about, as they come forward, you don't keep the proponents and the opponents separate, or do you?
I like,
Just-
like I say, as the gatekeeper, I like to, that's my personal preference. We run the proponents first. It's kind of like court. I want to hear all the evidence on one side first. The opponents get a chance to bash because they've heard everything that the proponents say. So then the opponents have a good roundabout. But then like when we come to court, the applicant is the defendant. He gets one last shot.
The rebuttal.
What's that?
It's the rebuttal.
Yeah. So to
That's where it
address anything-
sometimes gets a little bit ugly.
Yeah, and it could very well, and then you have to be careful how you balance that. I've been in some places where the applicant comes back, and I've seen some places where the opposition is given one last shot. I don't recommend doing that. I think you just everybody gets to unload, and then the applicant gets a chance to address everything that was brought up, because they're the one that's asking for the permission to do whatever it is that they're asking to do, and you're the ones that are having to sort the wheat from the chaff in that respect, right?
And one other thing, Todd.
Yeah, Daryl.
So we got a list of the people that want to make a public statement.
Yep.
Does the chairman then call those people?
It depends. Like when I'm working in Grant County Zoning Board has appointed me as the parliamentarian, and so they ask me to do that as an ex officio member. So you can have staff do it. Cottington County, Bob Fox, the chairman, he calls the people up. You know, it depends on how you want to do it. And again, and sometimes in situations like this tonight, or even smaller things, you don't have to be as formal. But when you're dealing with something that's highly litigious, you know, a really bad gravel pit, or a nudie bar, or a CAFO, or a wind tower farm, or something like that, where you know there's a large amount of people here, and you don't want to be wavering for hours, you want to have a very focused approach on how you deal with that request. That's fair to the audience, and fair to the applicant, and fair to you. Right?
So would the chairman have to appoint a gatekeeper that night then, or?
Well, you can. Some counties have it in their bylaws that specifically state that, you know, who is the gatekeeper, who's the parliamentarian, you know, what staff's function during the meetings. You know, you can do that within your bylaws. So you do it once at the beginning of the year, and that's how it works. Or you can do it on a case-by-case basis, and it's always at the chair's discretion on how you want to approach that.
Does
Good
that need to
questions.
be Publicized in the public notice at all, or anything, or just could be said before the meeting?
I'm sorry?
Does it need to be publicized in the public hearing or public notices at all, that we will be taking testimony by list?
Oh, well,
or-
okay, you want to just back up here? I'm going to tell you the newest thing that we're doing, and we're recommending across the district, is that when you publish the notice in the newspaper, you have who's making the application, what they're requesting, that there's a public hearing on this date, and public testimony is, you know, oral testimony is accepted, and written testimony is also accepted. But here's what attorneys and your Public Assurance Alliance attorneys are going to tell you to do. Put a cutoff date on written testimony. We recommend if the meeting is going to be on a Monday night or a Tuesday night, cutoff date's Friday at 12 o'clock, so staff can gather all the written materials and make sure that you have it over the weekend to review, because it's not fair to you, it's not fair to the applicant, it's not fair to the public when we have public hearings and people come up with a tome of, you got to read all this to make up your mind. Because the first question you're going to get asked in the deposition when the attorney says, you were presented 127 pages from blah, blah, blah concerned citizens group. Did you take that into consideration when you made your findings? And you voted on that night, and obviously you didn't read 127 pages. What I would recommend doing is anybody that shows up that night and they have written testimony that they didn't get in before the cutoff time, you accept it, you put it in a file, and it's not part of the record, but you took it. And can you do this? Yeah, we have, and it's being litigated again right now in several other communities, but it's like if you go to court, the judge doesn't let the attorney show up the day of and bring all kinds of new evidence, and that the defense didn't have an opportunity to review prior, during that, evidentiary proceedings. So we've been told that that's a good idea, and so we've been doing that for about 8 months in Brookings and, or not Brookings, but in Coddington and Grant and Hamlin, and I know Clark and Dual are starting to do that as well. So if you want to invite written comment, which we do, we want to have as much comment to be a part, you still need to have a cutoff date so everybody has an opportunity to digest it before you have to go through the hearing process.
The other thing on that additional testimony and rebuttals from the two parties, proponents and opponents, sometimes it gets a little bit heated and chair has to try and handle the crowd, and the rest of the group is wishing we would cut it off right now. And the chair isn't sensing that. He may stop at that point and say, I'm going to limit debate for and against to 2 more for and 2 more against without objection. Now, if 5 of you say, now we want it to go longer,
We want to hear it all.
that's an objection, you want to hear it all, then the chair says, then we'll hear it all. But if the rest of you, it's getting repetitious, this is getting late, there isn't anything else we're going to learn, they are not going to object, and the chair then can limit debate without objection to 2 more for, or whatever number you
or
want.
you can turn around and say, there's still 26 people that want to speak against this. Is there any of you that has anything to say that hasn't been said yet?
Yeah, exactly.
And that way you just maybe eliminated 15 people that want to testify.
It'll happen real quick.
We will take your name. We will write down that you are object to it. It becomes part of the record, but we're not going to, if that's okay with you. And that happens all the time in peer.
We're going to,
So the chair can use that without objection to judge what the board's thinking. If someone objects, one objection is all it takes, and you just move on.
could the board, at the beginning of the meeting, or say that there's we have a rule that if there's more than 40, a combination of more than 40 proponents and opponents, that we're going to limit the time for more than.
I think, yes, you can limit the time, but I think the
time.
Supreme Court in the Grant County case that I'm most aware of, it has to be reasonable. We just can't say you get 30 seconds.
No.
I think most people, if you say 3 minutes, most people don't even get a minute and a half or 2 minutes into what they got to say. I just hate it, don't like it, blah, blah, blah. That's what, there's a few of them, what I call, professional complainers, that come in that are really well prepared and well reversed. But at the same point in time, they've got to the point where they've written it out, they read it, they have a prepared written statement, and on the average, very rarely do we ever have to shut anybody down. And if it's at 3 and you can see that they're getting close to the end, as a parliamentarian, I'd say, it's been time, Mr. Chair, do you want to extend? And then they'll say, we'll give you 1 more minute. But
Could the board adopt that as a
we
permanent policy?
Yeah, I would
if there's
recommend
more than 40 or whatever number you choose.
Yeah, I think
That we're going to use a gatekeeper and we're going to.
we have bylaws, and Luke's written these bylaws for other counties, and Luke can provide those examples to you if you want to look at what those bylaws. You guys have bylaws right now. I know you do, but Luke could add. You could add to those bylaws and how you run the meeting. but it's a good thing to have those bylaws, because again, those bylaws establish when you're taking written testimony, what's our rules for evidentiary proceedings throughout the public hearing process. If you have it all laid out and you stick to it, no one's going to beat you up, or the attorneys will come at you, but they're going to have a harder time taking that on.
It's always good not to be arbitrary.
Yes, we have taken the arbitrary and capricious aspect of that, because on a cert review, which is what they get at a Board of Adjustment action, we eliminate that whole argument. They're going to still try to hit you with a de novo, look behind the curtain kind of a deal, but it helps bolster your decision. Next slide, please. We're going to, all great questions, and I'm not trying to cut anybody off, but I know that everybody wants to don't want to have to listen to me for all night either. But so we go through all those. We've talked about rules for comments, but after we explain generally what the rules of comments are, then we start the actual process, and that's where we have the staff report, and that's what Richard did, and he provided general overview. A couple more clicks, Richard. Then we ask the applicant or the representative to come up. We usually recommend prescribing a certain amount of time as well, and we see that anywhere between 10 and 20 minutes, depending on the complexity of the request. But in your bylaws, you should also have a recommendation, and there are some sort of standard on how long you'll listen to an applicant talk. Again, it makes them have to focus what they're asking for. Then we start the actual public hearing process. The chair says, well, now we're going to bring up the proponents and the opponents. Go ahead. Next slide. Keep going here. Let's see what Luke's asked. We've already talked about most of that stuff, and we talked about the written aspect. And so after we go through all the proponents, opponents, and we adjourn the hearing portion, okay, next slide. Then after you close that public hearing, if there's no more extra questions or comments, that's when we actually bring the applicant back, or any other persons that the board wants to ask questions of. It's after the hearing has been closed. It's still part of the public record, but we're not allowing anybody else to throw bombs in the process, right? So after we go through the applicant or any other questions that the board might have, the board will then, the chair usually will then turn around and say, well, now before we vote, we need to go to some sort of findings. And go ahead to the next slide. And the next one after that. And that's basically where we're getting to the decision. And why do we need findings? We need findings because when you get sued, you got to have some reason why we did this or why we didn't do this. And your findings can be very minimal, or they can be very specific. But basically, when you're doing your findings, you are stating the reasons how this application met the requirements of your ordinance. Now, you guys do it. You have some standard findings of fact that every conditional use or every variance has, and you usually read them at the beginning. And then if you have if you have multiple conditional uses or variances, you basically just say, okay, those are the findings that we read, and they basically meet the same findings as before. And maybe, Richard, there's something special about this request, and you just usually enter it. And that's fine. And that's a minimal approach to doing standard findings. Next slide, please. But really what the conditional use findings or even variance findings, they're just important for the record. It basically says we have the authority, and it has the notification for reasons for our decisions, and take away the arbitrary capricious. Next slide, please. Basically, most of us have in most counties and cities say that if the applicant comes in and through the testimony, and you go ask your standard findings questions, that's good enough. They've satisfied what we want. Next slide. I'm going to go through a couple things that what we do here, and sometimes it does extend the process a little bit, but it buttons things up really nice, especially in those controversial issues. So I'm just going to read an example of questions that we ask when we're establishing findings. So public hearings held, public hearing's been adjourned, there's been board discussion, and now we're getting ready to have findings, and after we do the findings, we vote. So what Luke or myself would do, this is a wind energy application. Does the board agree that the standard findings of fact identified in this section, and that's what you always read, has been addressed? Yep. Everybody agrees. We move on to the next one. Does the board agree that the application was submitted prior to the application deadline? Yep. Does the board agree that the application meets the term wind energy, whatever, you can use that for whatever? Yep. Does the board agree that this permit should not become effective until all required permits by the state, and that's if you have a CAFO or a wind farm or something like that? Does the board agree that the application testimony at this meeting allow the board to adequately review how the applicant will satisfy? Those are all the sections of the wind energy regulations that they addressed. The important statement in there is about the 7th word, testimony at this meeting, because that means you've considered the testimony in your decision-making process, because that sometimes will be, you'll get hit that, oh, you didn't even listen to us, you didn't even consider the testimony. Oh, no. We agree that the testimony supports what is required to do. So sometimes it's nice to have that. Does the board agree that the applicant demonstrated the ability to meet the setbacks? You know, and they do. Next slide, please. Does the board agree that the applicant submitted all the information that's necessary? Does the condition that the applicant needs a haul road or any other requirement has been met? Yeah. Does the board agree that based on the review of the application, information contained in the staff report, and testimony provided today, that there are no issues brought up which the zoning ordinance or the land use plan that the board feels needs to be addressed? They touched all the bases, right? Does the board agree that there are no other issues? Does the board agree that they're empowered to issue the permit? That's a really good question to have in there. Does the board agree that the application will not adversely affect the public interest? Because that's straight out of your ordinance. Does the board request the zoning officer prepare the findings of fact consistent with these questions and any other things that come up with for the board? And as long as we keep saying yes to these questions, we're getting closer to the decision. Next slide, please. Does the board agree that the conditions recommended by the staff or others should be agreed to by the applicant? Yes. Then final question. Does the board have any other recommended conditions to add to this permit? So if we're hitting yes all the way along, by the time we get to the last question, any last things that we need to add, the vote becomes perfunctory. You made the decision. Now, if we have no's in there, or we don't have consensus on all of those points, because those are all the things that you got to hit to get a wind energy system in Grant County, the answer is probably going to need to be no. It might be a split vote. Some people are going to look at, they didn't meet everything that they need to meet, and so I need to vote no. So again, the vote has been taken care of because you've adequately addressed all those things. You know, and normally, how it usually works when Luke's doing this in Coddington County, or when Bob Fox, the chairman in Coddington County, does, he reads the questions that Luke has prepared, and if no one says anything, that's a yes. You know, only time that, and then we keep rolling. And so yeah, it maybe adds an extra 2 minutes. But then what happens then is, after these questions have been answered, staff will have, sometimes they'll have prepared findings based upon what's there so that they can be taken care of that night, or the next day in the office, staff prepares the findings, the chair comes in, the chair agrees with the findings that were there, the chair signs the findings, and the permit's issued. There's different ways of handling that. That's just kind of an approach that we're looking. Last slide. And finally, the big thing that when we're talking about conditions at the very end of those findings, if we haven't talked about throughout the hearing, make sure that we talk about that those conditions are germane to the request. Don't be throwing things that have no nexus to the request in your conditions, because they need to be, if we require it for this person here, and it sounds goofy, we're going to have to apply that goofy standard to somebody else on a similar request. And so always make sure we don't want to be talking about some sort of a wind requirement or a signage requirement on something that has no basis or need for a sign. Why are we requiring you to put a sign on something that we don't want people to know about or see, or that's going on? Or you just know, again, what's the perception? If we're going to make you take out a bond on this, and the question is why? Why would we do that? So you got to have some basis. It should be something in your ordinance or in your land use plan. If you're going to be attaching conditions, they should be based upon something that you've already have in policy. The other quick thing I think too is that you should have something in your permits or in your findings that if you issue a conditional use or a variance and nobody takes out a building permit or executes or does anything within a year or two, it goes away. You should probably have something about whether or not the conditional use permit is transferable. Variances are tied to the land, so they get stuck. But some conditional uses you don't want to be transferable. Maybe your policy is all conditional uses are transferable except for CAFOs. They're only transferable if the guy that takes the permit agrees and signs the same letter of assurance that was originally handed out. Those are just some best practices. And again, I'm not next slide, I think. I'm not dogging anything that you guys do. You guys run a really good shop. You've got good staff that helps you. But if you just gleaned a couple things out of this presentation that as you're thinking about, specifically on those ex parte contacts, that's the one that you have the most control over. But with that, I'll just take any more questions if you want to talk about anything else, or if you guys want to go home, that's fine too.
I do. All those questions for the findings, findings questions, isn't that kind of burdensome to go through all those?
I would, again, what I'm saying there is like on some of those things, like what Lane did tonight, probably not as big of a deal. I got 100 people in there and I'm trying to justify why we voted a certain way. I want to know the answers to all those questions, because all of those questions that I just read, an attorney is going to ask you those same questions. Did you consider this when you were making your vote? And if you say, yeah, I did, that's what I thought about. I mean,
Well, basically, kind of do that in an understood fashion, at least.
most of you are doing that.
Yeah.
And again, you don't have to do this. I'm just saying what we have found. We were asked to come in and do some zoning in some counties that don't have, in Hamlin County, for example, where, nothing against the Hamlin County previous zoning officer, but she was the custodian. And for 4 years, it was not really run very well, and there was a lot of different legal issues that were being brought up in that county, so they asked us to come in and help. And so for us, and we're only there 2 days a week, and we only see these guys once a month, we wanted to establish a process that if and when we ever walk away, they could still be able to understand why they make the decisions they make. And so that's the best practice that we use.
And our zoning ordinance actually breaks down
Yeah.
the findings of facts, and that's what we go by step by step.
And again, it's just to what extent you want to be. And I'm not saying that you have to do any of this. I just know that in the last 3 depositions, all these questions that were asked, I was asked by an attorney saying, did they consider this? Did they look at this? Nowhere in the minutes, because you guys, we record things. Some of these places don't record things. Nowhere in the minutes does it say that they considered the testimony of the. And so if we have these questions, those questions get added as part of the minutes that were asked. The board then establishes their findings. Again, it buttons up legal things, so it might be a little bit overkill, but
The important thing is you need to do it on a consistent basis. You just can't introduce that for a K4 or wind energy project
Right.
that you're debating. You can't say tonight, we're going to handle findings of fact
Or the other
completely
thing
differently.
is, and what Cottington County has done is they've taken many of these questions and they've adopted them as standard findings of fact, and they adopt them at the beginning of the year. And so the very first question that was only dealing with your 4 or 5 things. What they do is they'll if there's 7 or 8 things like are we empowered, all these other questions, we adopt standard findings at the beginning of the year. We ask one question and it answers 9 of them.
Right.
So you maybe only end up asking 5 or 6 questions, and because you've already said that, our standard findings, which include this half of those questions.
That might speed up our findings of fact, because most of them are pretty standard questions. If we could
Even
put
if
them in there.
even with your ones here, if you only stick with the 6 or 7 questions that you got at the beginning of the year, you adopt a standard findings of fact, and Richard just says, do you agree that this application meets our standard findings of fact adopted at our board meeting on January 1st, 2019?
Well, but also the chair has to ask, are there any additional findings
Yep,
of fact?
and then is there any additional findings? And then are there any conditions, whatever?
Any conditions to
So, I mean,
request?
what you're doing is nothing wrong with the way you're
No.
doing it. Not whatsoever.
But we might be able to speed it up a little bit.
Or, and again, if you just want to, if you got something that's really gonna.
Easy ones.
Yeah, if you got something that you know is gonna be contentious,
And you
you're,
can't
you're
speak.
best off to overkill, because when you go to court, and it's not if, it's when, you wanna be prepared. Any other questions? I've really enjoyed talking to you guys tonight.
Can I ask you one just off the subject altogether,
Yeah.
your opinion on the Senate bill that wants to regulate setbacks for wind towers to 1,000 to
House Bill
1,500 foot?
1226 was
1226.
introduced last week. I talked to the county commission. I know Bob talked to the county commission this morning about it. It's being brought forward by several in the leadership, Gosh, Greenfield, Quam, and a few
Quam is a big
others.
leader.
Basically, what it's doing is it's establishing a statewide setback from residences and property lines for wind towers, which my opinion is it's a local control issue. The state should be out of those types. It's a zoning issue, this local control. Previously, whenever the state has tried to implement state standards for CAFOs or pick a use, it hasn't gone very far. But there will be a hearing in the next week or so. You get a chance to bend Reeds or anybody of the other representatives in your area, Wick, Mills, whoever. It's not a good bill. It's going to be up in front of the Energy and Commerce Committee next week. But basically, it's setting standards at a state level for something that we should be doing at a local level. And if that law was in place, you wouldn't have the 180 towers that have been built or are going to be built in Brookings County.
There basically would never be another wind energy farm in the state
No.
if it passes the way they have it written. Now, that could be
Yeah.
modified and committed to change the distances, but the whole issue is local control.
Yeah,
over
it's
those
a
types
local
of
control.
things.
It'd be no different. We had the same thing when back in 2004, the Department of Ag was trying to do some things on CAFO development and setting some state standards, and we had to battle back, not so much on the CAFO development, but just this is local control. You know, we can't treat Zebach and Brookings County the same because they're so disparately different. And so that's a bill that's going on out there that if you get a chance, you take a look, go up, look on South Dakota Codified Law on the internet, look it up. You can read it. I'm not sure why it's being proposed, who's backing it. I do know that there's a couple counties that have had some problems. They don't have zoning regulations, and so maybe that's what's pushing it. But we'll see. But 1226 is one that I would encourage you all to take a look at and talk to your legislators about. Thank you, Mike.
Thanks, I just wanted your input on that.
Well, thank
The
you very
county
much.
took a position this morning
Yeah.
to oppose it.
Send Bob out there
Commission
and
did.
rattle some cages.
Just coincidence, we had about 3 or 4 phone calls today in just regards to that, people calling in and checking on our wind ordinances and what the setbacks are.
Yeah, it's
Local people, Richard?
No,
no, and the issue is it's just bad form. It's just bad form. I mean, if I wanted people in Pierre to tell me how tall my grass could be, I'd live in Pierre. But I'm kind of a local control freak. Anyway, thanks a lot, guys. I really appreciated it.
you.
And next month you'll have Luke back. So,
And
Have
again-
a cookie. Have a cookie on your way out.
oh, thank you.
Thank you, Todd. We need these refresher courses. You know, some of us have heard this more than once, and some of you probably haven't heard this at all, but we definitely need these refreshers. So, again, thank you.
I should also make a quick plug. If you have the opportunity, the South Dakota Association of County Commissioners is going to be having their training in March, but 4 hours of that, we've got myself, Luke, we got some people from Lincoln County and Yankton, and we've got your attorneys that represent you through the Public Assurance Allowance. We're doing 4 different sessions on planning and zoning, and that can be for planning commissions. You don't have to be a county commissioner to come. So if you want to come to Pierre on March Wednesday the 13th or 14th, I think that is. There's an afternoon session where we're going to do a little bit on, not so much on this, but Luke and I are going to talk about, do you think your ordinance is effective and is it legal? I know there's going to be a little bit of questions on how to run a Board of Adjustment meeting. We're going to have just kind of a planner's roundtable where we can just pick and choose and talk about several topical issues. And then Jack Heeb and Zach Peterson are going to talk on some of the legal issues that have been happening in the last year. If you've never heard Jack Heeb speak, he's a very he's easy to listen to, and very insightful. And he's the one that's basically has defended all the counties and the cities over the last 5 or 6 years on any Supreme Court case that's popped up. So next March, I think Bob's probably has that access to that information. So I'd encourage you, if you want to get a little bit more education, it's a good opportunity. All right, I'll be quiet now. Thanks.
Okay, moving on, department reports. Mr. Hill?
Yes, the first thing, at the last meeting, we talked about going paperless. And right now, they're looking at possibly March, having the new little tablets. If not March, they're pretty confident it'd be April. And then the last thing I've got is our wind towers. Right now, we've got 180 wind towers permitted in Brookings County. That's 141 spinning and 39 under construction. And we're going to end up with 363.1 megawatts of renewable energy. And this county has taken in $507,272 in zoning fees that went into the general fund. So that's why we support renewable wind energy systems,
Okay, thank you, Mr. Hill.
and that's the end of my report.
Yes, just on the next March meeting will be on Thursday, March 7th at 7 p.m. instead of on Tuesday. So because of the annual meeting for the townships being on Tuesday, we moved our meeting date to Thursday, March 7th at 7 p.m. So, and that's all that I have.
Okay, anybody have anything else? Now we need a motion to adjourn. Motion by McHugh, a second. Second by Ford. Meeting adjourned.
Thank you.